many forms, many hidden, is still a huge issue everywhere, even in societies we think of as, modern.
Absolutely. And that's where the law comes in. It's not just dry text.
No, exactly. Laws are these vital tools, right? They drag these private struggles out into the open, into the legal world, offering a lifeline when it feels like there's nothing
A
else.
critical lifeline.
So today we're diving deep, really deep, into a landmark piece of legislation from India, the Protection of Women from Domestic Violence Act 2005. You'll often hear it called the PWDVA. It kicked in around 2006.
It really was transformative. It wasn't just tweaking existing laws.
Yeah.
It fundamentally changed how India understood and responded to domestic abuse.
That's what we want to unpack, what makes it so revolutionary. Our mission today is to explore its whole framework, look at the really innovative parts, and crucially, understand its impact in the real world.
Yeah, we want to give you a really solid, easy-to-grasp understanding of this act. Show you how it acts as both a shield for women and, honestly, a sword against abuse, cutting through some really old societal norms.
So where are we going with this?
Well, we'll start right at the beginning, looking at its roots in the Indian Constitution. Then we'll unravel its definitions, how it defines domestic violence, who it protects, what counts as a domestic relationship, and you'll see just how broad and, frankly, revolutionary those are.
Okay.
From there, we'll look at the support systems it set up, like protection officers, NGOs, then the actual legal protections, the release available, and finally, how it's enforced, how people are held accountable, what gives the act its teeth.
And the whole time, we're seeing this victim-centric approach, right? Trying to tackle the whole problem, not just bits of it.
Spot on. It's holistic.
Okay, so let's start at the beginning. This law, the PWDVA, enacted September 13th, 2005, effective October 26, 2006. But like you said, its origins go way deeper than those dates.
Absolutely. It wasn't created in a vacuum. It was a direct answer to a really deep-seated, pervasive societal problem. And critically, it's anchored in India's constitutional promises.
So it's about making those promises real for women in their own homes.
Precisely. The act basically takes fundamental rights from the Constitution and makes them tangible, makes them work for women facing violence.
Right.
Think about Article 14, equality before the law. The PWDVA aims to ensure women get that equality, get justice when facing domestic issues.
Right.
Then there's Article 15, no discrimination based on sex. This act tackles violence that disproportionately hits women, so it's directly countering that kind of discrimination within the family unit itself.
Okay, equality, non-discrimination. What else?
The big one, arguably, is Article 21, the right to life with dignity. The PWDVA says very clearly domestic violence stomps all over this basic human right. It insists that living free from violence, living with dignity, isn't just a nice idea, it's a constitutional must, and the state has to protect it.
Wow. So it frames domestic violence as a fundamental rights violation.
Exactly. The act itself says its purpose is more effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family. So it's not just about, stopping someone getting hit. It's about upholding that constitutional promise of a life with dignity.
That's powerful. And it's broad, too, isn't it? Violence of any kind occurring within the family and anything connected to it. That sounds like a major shift from just focusing on physical stuff.
Huge shift. It explicitly brings in psychological abuse, sexual abuse, economic abuse. It takes this really holistic view. Understanding abuse has many faces, some visible, some not so much.
And this broad approach extends geographically, too.
Yep. Since 2019, after the changes in Jammu and Kashmir, it applied to the whole of India. Uniform protection. And relationally. It goes way beyond just marriage.
Ah, okay. So not just husband and wife.
Not at all. It covers diverse family setups, live-in relationships, blood relatives, adoptive relationships, joint families. It makes it one of India's most progressive laws in that sense. It gets that violence happens in all sorts of relationships, even ones not formally recognized elsewhere. Hashtag B. What did the domestic relationship truly mean? Section 2.
So who exactly gets protection under this act? Section 2 defines the aggrieved person, right?
Yes, Section 2A. It defines an aggrieved person as any woman who is or has been in a domestic relationship with the respondent and who alleges to have been subjected to any act of domestic violence.
Any woman. That seems deliberately inclusive.
It is. It doesn't matter about her background, her religion, her class. If she's in that situation, she's covered. And notice the is or has been part.
Ah, so it covers former relationships, too.
Critically, yes. It recognizes that the violence, the threat, the control, it doesn't necessarily stop when the relationship ends. Sometimes it even gets worse after separation.
That's a really important practical point. It
Right.
offers a safety net even after leaving.
Exactly. The law gets that the impact lingers, the danger can
Okay,
persist.
so that's the aggrieved person. What about the domestic relationship itself? Section 2, you said it was expansive.
Incredibly expansive. It covers marriage, obviously, but then it adds relationships in the nature of marriage.
Which means,
Live-in relationships,
yeah.
basically. Cohabiting partners. That was a huge step, acknowledging how society was changing. Then it covers consanguinity blood ties. Think mothers, sisters, daughters facing abuse from other family members.
Okay.
Adoption is covered too. And relationships within joint family arrangements, the extended family settings common in India.
So it maps onto the reality of many Indian households. And you mentioned the shared household concept earlier as being key, Section 2's, I think.
Yes, Section 2. And this is where it gets really interesting and, frankly, revolutionary, especially concerning property.
How so?
It defines the shared household as where the aggrieved person lives or has lived in that domestic relationship. It could be owned or rented by either party, jointly or singly. But here's the absolute kicker.
So,
It includes households belonging to the joint family of which the respondent is a member, even if the respondent doesn't own it, even if the woman has no ownership title.
wait, really? So she could be living in her father-in-law's house, for instance.
Exactly. Her right to reside there isn't dependent on her or her husband owning the property. This is a massive legal innovation. It directly tackles the issue of women being thrown out onto the street because the house isn't technically in their or their husband's name. It prioritizes her right to shelter. We'll definitely dig into the case law on this later. It's fascinating. #tag Hopiate. The comprehensive definition of domestic violence, Section 3.
Okay, that's huge. Let's get to the core then. How does Section 3 actually define domestic violence? You said it was one of the most comprehensive definitions globally.
It really is. It aims for a holistic understanding. Recognizing abuse isn't just one thing. It looks at the overall facts and circumstances to see if violence happened, acknowledging it can be subtle, a pattern, not just isolated incidents. #tag1. The 4 pillars of abuse, Section 3A, with explanations.
So it breaks it down into pillars. Let's start with the most obvious one, physical abuse. Explanation I. What falls under this?
Right, this is any act causing bodily pain, harm, danger to life, limb, health, or impairing health or development. So yes, it includes severe assault, but it also explicitly lists things like slapping, beating, kicking, pushing.
Even pushing.
Yes. Or physical restraint, confinement, throwing things at someone with intent to harm. Criminal intimidation,
Yeah.
criminal force, those are also included. It covers a spectrum, recognizing that even acts that might seem minor to outsiders cause real harm and fear.
Okay, then pillar 2, sexual abuse. Explanation I3. This must be incredibly sensitive territory within a domestic relationship.
Extremely. The Act defines it as any conduct of a sexual nature that abuses, humiliates, degrades, or violates her dignity. This includes forced sex, forcing her to watch pornography, any form of sexual harassment, unwanted advances.
So it makes it clear that marriage isn't consent for everything.
Absolutely. It upholds a woman's bodily autonomy and dignity even within marriage. That's a critical stance against marital rape, even if India-specific rape laws are still evolving on that front. The PWDVA recognizes sexual coercion within the home as abuse, plain and simple.
Okay, pillar 3, verbal and emotional abuse. Explanation I. This is the invisible kind, right? But it can be devastating.
Totally. It can destroy someone's self-worth. The act includes insults, ridicule, humiliation, name-calling, repeated threats causing psychological harm. Think constant character assassination.
Or those specific, culturally loaded insults.
Exactly. Insults about not having children or not having a son, those are explicitly mentioned as examples. Threats to harm people she cares about. Any repeated harassment that amounts to mental torture. This kind of abuse often flies under the radar, but it's incredibly damaging and often, sets the stage for physical violence later.
It erodes everything. And the 4th pillar, specific to India, harassment for dowry. Section 3B.
Yes, this is harassing, harming, injuring, or endangering the woman or anyone related to her to coerce them into meeting unlawful demands for dowry, property, whatever. Dowry violence is such a huge, persistent problem in India, intercepting with all other forms of abuse, so its specific inclusion was vital.
Now, Section 3, economic abuse. You said this was the first law in India to explicitly recognize this. Why is that such a big deal?
It's a massive deal because economic control is one of the primary ways abusers trap victims. It creates dependency, making it incredibly hard, sometimes impossible to leave. Recognizing it as violence gives women a legal tool to fight back against that control.
So what does economic abuse look like under the Act?
It's broken down quite clearly. First, Section 3, deprivation of resources. This means withholding money for basic necessities, food, clothes, medicine, refusing to pay rent or maintenance, preventing her from using or accessing her stridhan, that's her own property, gifts received before or during marriage, withholding funds needed for the children. It's about controlling the basics of survival.
Wow. So denying access to household funds counts.
Absolutely. Then, Section 3(4)(b), asset manipulation. This is things like selling off shared assets, house, car, jewelry without our consent, disposing of stridhan, alienating shares or bonds, selling household goods. It's about stripping away any financial security she might have.
Undermining her completely.
Exactly. And third, Section 3(f) is access restriction. This is about blocking her use of parts of the shared household she's entitled to use, maybe locking her out of the kitchen, denying access to a bathroom. It's a way of controlling her physical space and making her life miserable within the home itself.
That sounds incredibly insidious. And you mentioned earlier the stats on this are staggering.
They are. Studies suggest over 70% of domestic violence victims in India face economic abuse. But it's often normalized, isn't it? Financial control within families is sometimes seen as just how things are.
Right. He handles the money.
Exactly. So having the law explicitly call it out as abuse is incredibly powerful. It validates women's experiences and gives them a legal basis to challenge that control, which is often the key to regaining independence and safety.
Okay, so we have these really strong definitions, this broad scope. But a law is only as good as its implementation, right? How does the PWDVA actually work on the ground? It sets up this role of the protection officer, the PO. That sounds quite innovative.
It really was. Sections 8 and 9 detail this. The idea was to create a dedicated official, a bridge between the victim and the justice system, someone specifically tasked with helping women navigate the process.
So who appoints them? What's their mandate?
State governments have to appoint POs in every district, making them accessible. The law prefers they be women as far as possible, which makes sense for victim comfort. They need certain qualifications and experience.
So they're meant to be professionals.
Yes, and they work under the magistrate's control, so
Yeah.
there's judicial oversight. They're also considered public servants under the Indian Penal Code, which gives them some legal protection for doing their job in good faith.
That sounds good on paper, but what's the reality? Are there enough POs?
That's the challenge.
Yeah.
Honestly, in many places there's a shortage. Often, existing government officials get this added to their workload, which, well, you can imagine it stretches them thin and impacts how much they can actually do.
Right, limited resources. But assuming they can do the job, what are their specific functions? Section 9 lists quite a few.
It does. 9 critical functions. They assist the magistrate, providing reports. They file the domestic incident report. The DIR, that's the official record of the abuse, really important evidence.
Okay.
Crucially, they can file the actual application for relief orders, protection, residence, monetary, etc. on behalf of the victim. This is huge for women who might be scared, injured, or just don't know how.
Takes the burden off her shoulders.
Exactly. They also have to ensure she gets access to free legal aid. They maintain lists of local service providers, shelters, doctors, counselors. They coordinate getting women into safe shelters, arrange medical exams if needed.
So a real support role.
Absolutely. They even help enforce monetary orders, chasing up payments. They are meant to be the operational backbone, that multifaceted support system, making the act accessible and effective.
Beyond these official POs, the Act also brings in NGOs, right? Section 10 recognizes them as partners.
Yes, and that was very smart. It formally acknowledges the vital role civil society plays. NGOs are often the first point of contact for women.
They have that community trust.
Precisely. The Act requires them to be properly registered, ensuring they're legitimate organizations focused on women's rights. And importantly, it gives them legal immunity for actions taken in good faith.
So they can intervene without fear of being sued.
Exactly. It encourages them to be proactive. They're empowered to do 3 key things: record DIRs, just like POs, arrange medical exams, and provide access to shelter homes.
So multiple doors open for help. You can go to a PO or you can go to a registered NGO.
Correct. And ideally, they work together. The best results, as noted by groups like the Lawyers Collective Women's Rights Initiative, happen where government agencies and NGOs collaborate closely, pooling their resources and expertise.
Do we see that happening?
We do see good models in states like Maharashtra, Kerala, Delhi. They've built strong networks, public-private partnerships. It creates a much more comprehensive safety net, legal help, medical aid, counseling, shelter, all coordinated. Because tackling domestic violence needs everyone pulling together.
So we have POs, we have NGOs, but the government itself still has homework to do under Section 11, doesn't it? It's not just about setting up the system, they have to actively make it work.
Absolutely. Section 11 puts the onus squarely on central and state governments to ensure the Act achieves its goals. Legislation alone isn't a magic wand.
So what are they mandated to do?
Several key things. Section 11A, media publicity. They need to run regular awareness campaigns. TV, radio, print, digital. Getting the word out in different languages, reaching rural areas, maybe using folk media, making sure people know their rights and where to go for help.
Public education, basically.
Yes. Then 11B, training. Periodic sensitization and awareness programs for police, judges, POs, other officials. This isn't just about rules, it's about understanding the dynamics of violence, trauma-informed approaches, how to handle cases sensitively and effectively, changing mindsets.
That sounds critical, especially for police and judges.
Hugely critical. Then 11C, interministry coordination. Getting different government departments, law, home affairs, health, women and child development to work together. Domestic violence isn't just the legal issue. It's a health issue, a social issue. So joint protocols, resource sharing.
Breaking down silos.
Hopefully. And finally, 11D, protocol development. Creating standardized procedures for things like filing DIRs, processing applications, how POs, police, and NGOs coordinate. Aiming for consistency across the country.
Is that consistency happening?
That's still a major challenge. Implementation quality varies a lot between states. There's definitely a need for stronger central oversight and regular reviews, using data and feedback to see what's working and what's not.
Okay, let's shift gears to the actual legal process. How does a woman experiencing violence actually start using this law to get help? Section 12 talks about filing an application. Who can do that?
The Act makes this really accessible. The application can be filed by the aggrieved woman herself, obviously, but also a protection officer can file it for her. Or, interestingly, any other person can file it on her behalf, as long as she consents.
Any other person, like a friend or a relative?
Yes, or an NGO worker. This flexibility is vital. Think about women who are physically confined, too scared to act themselves, or maybe lack the literacy or knowledge to navigate the system. It opens up pathways.
And what can she ask for in that one application?
That's another streamlined aspect. A single application can seek multiple reliefs at once. Protection orders, residence orders, money for support, child custody, compensation for harm done, all in one go.
So no need to file separate cases in different courts for different things.
Exactly. It avoids that fragmentation, which saves time, money, and a lot of emotional energy for the victim. It's designed to be efficient.
And is it fast? Are there deadlines?
The Act pushes for speed. Section 12(4) says the first hearing must be within just 3 days of filing the application. That's quick.
3 days. Wow.
And Section 12(5) says the magistrate should try to dispose of the whole case within 60 days from that first hearing.
60 days? That seems ambitious.
It is ambitious, and reality might differ, but it signals the urgency. These aren't cases that can wait. Delay means continued risk. The law recognizes that. And when the magistrate looks at the case, they must consider any domestic incident report filed by a PO or service provider.
That official record we talked about?
Yes. And crucially, the standard of proof is different from a criminal trial. Here, it's preponderance of evidence, meaning she needs to show it's more likely than not that the violence happened. It's a lower bar than beyond reasonable doubt, which makes it more feasible to get protection orders quickly based on the available evidence, even if it wouldn't meet a criminal standard yet.
Okay, the process starts quickly. How about informing the other party, the respondent? Section 13 deals with serving notice. Is that fast too?
Yes. The law keeps the pressure on. The PO has a maximum of 2 days to serve the notice on the respondents.
Just 2 days.
2 days. At their home, their workplace. There are rules for alternative service if they're avoiding it, even getting police help if needed. And the PO just declaring they've served it is enough proof. It cuts down on those delaying tactics, oh, I never got the papers.
Right, prevents getting bogged down in procedural games.
Exactly. Keeps the focus on the substance, the violence, and the need for protection.
What about counseling? Does the law push for reconciliation? Section 14 mentions it.
It allows for it, but carefully. The magistrate may suggest counseling, either together or separately, but it's not mandatory. It depends on the case, and crucially, both parties have to agree.
Consent is key.
Absolutely, and safety is paramount. If joint counseling seems risky, separate sessions are the way to go. The counselors also need to be properly qualified, trained in domestic violence issues, understanding power dynamics, trauma, safety planning, It's not just generic relationship counseling.
And it can't drag on forever.
No. If counseling is ordered, the next court hearing has to be within 2 months. It prevents counseling being used as just another stalling tactic. The courts have to be vigilant, though. Ensure it doesn't become a way to pressure victims into compromises that aren't safe or just.
Okay, now let's get back to that concept you called revolutionary, residence rights, Section 17. You said it disconnects the right to live somewhere from actually owning it. Can you unpack that? This feels like a really major departure from traditional property law.
It absolutely is. Section 17(1) is crystal clear. Every woman in a domestic relationship has the right to reside in the shared household. And here's the core of it: whether or not she has any right, title, or beneficial interest in the same.
So ownership is irrelevant to her right to live there.
For the purpose of this act, yes. It creates a statutory right to residence based on the relationship and the fact of shared living, not based on property deeds. This was designed specifically to combat the reality where women, especially daughters-in-law and joint families, had no legal right to the house they lived in, even for decades, and could be thrown out at will if the relationship soured.
Even if the house belongs entirely to, say, her father-in-law.
Yes. If she lived there in a domestic relationship with the respondent, her husband for instance, it counts as the shared household for her protection under this act. Section 17(2) adds that she cannot be evicted or excluded except according to procedure established by law, meaning the respondent can't just lock her out. They'd need a proper court order, which is unlikely if she's seeking protection under PWDVA.
This must have caused some waves legally. How did the courts handle this radical idea initially? You mentioned the S.R. Batra v. Taruna Batra case from 2007.
It definitely caused waves. And S.R. Batra is a really important, though initially limiting, interpretation from the Supreme Court. What happened there was the court looked at the definition and seemed to narrow it.
Oh, so?
They basically said the shared household had to be one belonging to the husband, or taken on rent by him, or a house where the husband was part of a joint family that owned it. Crucially, they suggested that if the house belonged solely to the mother-in-law and the husband had no ownership rights in it himself, then the daughter-in-law couldn't claim it as her shared household under the PWDVA.
So that interpretation seemed to tie it back to the husband's property rights, didn't it? Undermining the PWDVA's intent.
It did seem that way, yes. It created significant confusion and, for a number of years, made it harder for women living in houses owned exclusively by in-laws to claim their residence rights under this specific act. It was a setback, showing how judicial interpretation can sometimes, perhaps unintentionally, constrain a progressive law's reach based on more traditional property concepts.
Okay, so that was the situation after Batra. But then you mentioned a later Supreme Court case, Satisha Ahuja v. Sneha Ahuja, in 2020. Did this change things?
Dramatically. Satisha Ahuja was a major course correction. The Supreme Court revisited the issue, looked closely at the PWDVA's aims and language, and effectively overruled the restrictive interpretation in Batra.
So what did Satisha Ahuja clarify?
It clarified that the shared household does not need to be owned or co-owned by the husband. The court emphasized that the definition in Section 2 is clear. It's where the person lives or has lived in a domestic relationship. The crucial factor is the shared living, the existence of the domestic relationship within that specific household, not the ownership title.
So even if the house is solely owned by the father-in-law or another relative?
Yes. If the woman lived there with her husband, the respondent, as part of their domestic life, it qualifies as her shared household under the PWDVA, and she can claim the right to reside there under Section 17. The Satisha Ahuja judgment explicitly stated that the Batra interpretation didn't reflect the true legislative intent, which was to provide effective protection against homelessness caused by domestic violence.
That's a huge clarification. It really brought the law back to its intended purpose, didn't it? Protecting the woman's right to shelter based on the reality of her life, not just property papers.
Absolutely. It significantly strengthened residence rights, especially for women in joint families, which is so common in India. It affirmed that the PWDVA's right to residence is a unique statutory right linked to the constitutional right to life with dignity, Article 21, and shouldn't be defeated by traditional property law technicalities. It showed the law evolving to meet its protective goals.
Okay, so the right to residence is secured. What about stopping the abuse itself? Section 18 deals with protection orders. These sound like the main tool for immediate safety.
They are. They're the magistrate's primary way to put an immediate stop to the violence and harassment. Section 18 lays out a comprehensive list of things the magistrate can prohibit the respondent from doing.
Like what specifically?
Well, first and foremost, committing any act of domestic violence, Physical, sexual, verbal, emotional, economic. It's a blanket ban. Second, aiding or abetting anyone else in committing violence. Can't get friends or relatives to do the dirty work.
Oh,
Third, entering the victim's workplace or, if she's a student, her school or college, or any other place she frequents. This tackles stalking and harassment outside the home. Fourth, attempting to communicate in any way, phone, email, text, in person, through others. This is crucial for stopping psychological pressure and intimidation.
cutting off all contact.
If necessary, yes. Fifth, alienating assets, operating bank lockers or bank accounts used or held by both parties or her street hand without the court's permission, protects her financially. Sixth, committing violence against her dependents, relatives, or anyone helping her. Recognizing abusers often target the support network.
Isolate the victim.
Exactly. And seventh, the magistrate can prohibit any other act needed in the specific circumstances. It's flexible. These orders can be temporary, interim, or final, and crucially, violating a protection order is a crime in itself.
Ah, so it has consequences.
Yes, imprisonment or a fine or both. That gives these civil orders real teeth.
So Section 17 gives the right to reside, and Section 19 provides the specific court orders to make that right effective. Residence orders.
Precisely. Section 19 details the practical orders a magistrate can issue to protect her housing situation, building on the Section 17 right.
What kind of orders are we talking about?
6 main types under Section 19(1). First, A, restraining the respondent from dispossessing her or disturbing her possession of the shared household. Basically, to stop him kicking her out or making her life impossible there. Second, B, directing the respondent to remove himself from the shared household.
The court can order the abuser to leave.
Yes, if necessary for her safety. Third, C, restraining the respondent or his relatives from entering any portion of the shared household where the victim lives, creating a safe zone within the house if they have to cohabit. Fourth, D, restraining him from selling or transferring the shared household or creating any liens on it, protects the asset.
Okay.
Fifth, restraining him from giving up his own rights in the shared household without the court's okay, again safeguards her position. And sixth, F, if he is ordered to leave, the court can direct him to provide alternative accommodation for, of the same standard, or pay rent for such accommodation.
So she shouldn't be left worse off financially just because he has to leave for her safety.
That's the principle. And there's that really interesting proviso to 19(1)B, the order directing someone to remove themselves from the shared household. It specifically says, no order under Clause B shall be passed against any person who is a woman.
So a magistrate cannot order a woman, like a mother-in-law or sister-in-law, to leave the shared household under this specific clause.
Correct. It's a unique protection, recognizing women's vulnerability to homelessness and preventing the act being used, say, by a son against his own mother in these disputes. It shows careful thought about complex family dynamics.
And how do courts apply these residence orders in practice? We talked about Satish Ahuja clarifying the shared household definition. Are there other cases showing how these rights play out?
Definitely. High courts have frequently reinforced the spirit of Sections 17 and 19. Take a case like Neetu Mithal v. Kantamittal from the Delhi High Court in 2008. Cases like this often involve daughters-in-law seeking to stay in properties owned by in-laws.
So situations where trauma might have initially caused issues.
Exactly. But high courts, even before Satish Ahuja fully clarified things at the Supreme Court level, often emphasized the PWDVA's goal. Judgments like Neetu Mithal talked about the paradigm shift. The act intended moving away from strict property ownership towards a rights-based approach focused on the woman's dignity, security, and her constitutional right to shelter under Article 21.
So they were reading the law purposively, looking at why it was enacted.
Precisely. They affirmed the woman's right to stay or ordered the husband-in-laws to provide suitable alternative accommodation if cohabitation was impossible. These high court judgments were crucial in building the jurisprudence, reinforcing that the PWDVA aimed to protect women from being rendered homeless due to domestic strife, even if traditional property law might have pointed elsewhere. They helped pave the way for the broader understanding confirmed later in Satish Ahuja.
Okay, so physical safety and housing are covered. What about the financial fallout? Section 20 deals with monetary relief. You mentioned earlier it's more than just basic maintenance.
Much more. It's designed to provide comprehensive economic support, recognizing the financial damage violence causes, and helping women regain independence. Section 21 lists what can be claimed.
Such as?
Loss of earnings if the abuse made her lose her job or miss work, medical expenses for physical injuries, therapy, counseling, the whole gamut. loss caused by destruction or damage to property, including her stride hand.
So compensating for tangible losses.
Yes. And then there's maintenance for herself and her children, covering basic needs like food, clothing, shelter, education. Importantly, this can be claimed in addition to any maintenance she might be entitled to under other laws, like Section 125 of the Criminal Procedure Code.
So she can stack the claims, use all available legal avenues.
Yes, the PWDVA remedies are explicitly stated to be in addition to, not in lieu of, other laws. This is vital for comprehensive support.
How does the court decide how much money to award?
Section 22 says it must be adequate, fair, and reasonable. The court looks at her needs, the children's needs, the standard of living she was used to, both parties' income and resources, and the respondent's other obligations. It's a balancing act.
And can the court actually make sure the money gets paid? Enforcement can be tricky.
The Act gives the court strong tools here. Section 26 is quite innovative. The court can order the respondent's employer to deduct the amount directly from his salary.
Wage garnishment, basically.
Exactly. Or order someone who owes the respondent money to pay the victim directly. They can attach his property to recover the amount. They can even convert the PWDVA monetary order into a maintenance order under Section 125 CRPC, which has its own robust enforcement procedures. These measures really help ensure the orders aren't just paper tigers.
Domestic violence obviously takes a huge toll on children who witness or experience it. How does the PWDVA address their needs? Section 21 is about custody.
Yes, it allows the magistrate to grant temporary custody of the children to the aggrieved mother during the proceedings. The absolute priority is the children's safety and well-being, protecting them from further harm or exposure to conflict. The orders can also cover things like ensuring their education and medical needs are met.
What about the other parent's access? Visitation.
The magistrate can make arrangements for the respondent to visit the children, again under Section 21, but safety is paramount. Visits might be supervised or ordered to happen in a neutral place, and the proviso is critical. The magistrate can refuse visitation entirely if they believe it would be harmful to the child's interests.
Based on what?
History of violence, the child's own wishes if they're old enough, potential for trauma. The National Commission for Protection of Child Rights rightly points out that children witnessing domestic violence is a form of child abuse. It's important to remember these are temporary custody orders under PWDVA. Permanent custody decisions usually fall under family courts and personal laws.
Okay. Then Section 22 talks about compensation orders. This seems different from the monetary relief for losses we just discussed.
It is. Section 22 allows the magistrate to order the respondent to pay compensation and damages for the injuries suffered, and that includes mental torture and emotional distress.
Ah, so compensating for the psychological harm.
Exactly. It acknowledges the invisible scars. This money could potentially cover therapy costs, but it's also about recognizing the humiliation, the loss of dignity, the emotional pain caused by the abuse. It's compensation for the non-material harm awarded in addition to other monetary reliefs. It's a way the law tries to provide some measure of justice for the deep emotional wounds inflicted.
Given the danger often involved, waiting even 60 days might be too long. Does the Act allow for faster emergency protection?
Absolutely. Section 23 is designed for exactly that immediate relief when there's imminent risk. It allows for two types of urgent orders.
Okay, what are they?
First, under 23.1, the magistrate can grant interim orders during the case. Based on the initial application and maybe affidavits, they can issue temporary versions of any of the main release, protection, residence, etc. These stay in place while the case proceeds, providing immediate safety.
So a temporary shield while the full case is heard.
Precisely. But then, under 23.2, there's something even faster. Ex parte orders.
Ex parte meaning?
Meaning the order can be granted based only on the victim's application and affidavit without even hearing the respondent's side first.
Wow. That sounds drastic. When would that happen?
When the magistrate is satisfied, based on the victim's affidavit, that the respondent is committing violence, or is likely to, and that delaying the order to hear the respondent first would likely cause immediate and serious harm to the victim. It acknowledges that sometimes waiting even a few days for the other side to appear could be dangerous.
What's the standard of proof for that?
It's a prima facie standard. The magistrate just needs to be convinced on the face of it that violence has likely occurred or is likely, and immediate protection is needed. The Act stresses urgency here, and these ex parte orders can cover all the release, protection, residence, money, custody.
But is that fair to the respondent not getting heard?
It's a temporary measure for immediate safety. The respondent has the right to come to court later and apply to have the ex parte order modified or canceled. So due process is still there, but the Act prioritizes stopping immediate harm first. #AV. Enforcement, accountability, and impact.
Okay, so the court can issue all these powerful orders, protection, residence, monetary, even emergency ones. But how does the system make sure they're actually followed? Let's talk enforcement, sections 24 to 29. Section 24 says parties get free copies of orders. Why is that step important?
It seems small, but it's about access to justice. Everyone involved gets a free copy so they know exactly what the order says, what their rights and duties are.
Yeah.
It empowers the victim to know what she's entitled to and helps POs and police enforce it without cost being a barrier.
And how long do these orders last? Especially protection orders.
This is key. Section 25(1) says protection orders remain in force until the aggrieved person applies to have them discharged.
So they don't just expire after a year or something.
No. They provide ongoing long-term security. The burden isn't on the victim to keep renewing it. The protection stays unless she feels safe enough to ask the court to lift it. This recognizes domestic violence often involves a persistent risk. Of course, Section 25(2) allows either party to apply for modification if circumstances genuinely change.
What if the abuser moves to a different state to avoid the order?
The Act thought of that. Section 27(2) makes any order passed under PWDVA enforceable throughout India, so moving won't help them escape it. This is crucial for victims who might also need to relocate for safety. It allows for interstate coordination.
And how are these orders actually enforced procedurally?
Section 28 links many key procedures applications, orders under Sections 18 to 23, and penalties for breach under Section 31 to the Code of Criminal Procedure, CRPC. This hybrid approach is powerful. It gives these civil remedies the procedural backing of criminal law, things like police assistance, quicker processes, stronger enforcement tools.
So using criminal procedure tools for civil protection goals.
Exactly. And finally, there's the right to appeal under Section 29. If either party is unhappy with the magistrate's order, they can appeal to the Court of Session within 30 days. This ensures judicial oversight, a chance to correct errors. But importantly, filing an appeal doesn't automatically pause the original order unless the appeal court specifically grants a stay. Protection continues during the appeal.
You mentioned earlier that violating a protection order is a crime. Section 31 details the penalties. How serious are they? This is where the teeth really show, right?
Absolutely. Breaching a protection order or an interim protection order isn't just contempt of court. It's a specific criminal offense under Section 31. The punishment? Imprisonment for up to 1 year or a fine up to $20,000, or around $240 USD, or both.
So jail time is possible for violating a civil protection order.
Yes. This criminalization is a major deterrent, and Section 32(1) makes this offense cognizable and non-bailable.
Remind us what that means again?
Cognizable means the police can arrest the respondent without a warrant upon receiving information about the breach. They don't need to wait for court permission. Non-bailable means bail isn't automatic. It's up to the court's discretion, reflecting the seriousness. This empowers immediate police action to protect the victim when an order is violated.
That sounds incredibly responsive. And what about proving the breach? Domestic violence often happens in private.
Section 32 addresses this directly. It states that the court can conclude that the offense was committed based solely on the testimony of the aggrieved person.
Her word alone can be enough.
Yes. This is a vital provision. It acknowledges the evidentiary challenges, the lack of witnesses, and gives significant weight to the victim's account in cases of breach. It prevents perpetrators from getting away with violations just because nobody else saw it.
That's huge. So strong penalties for the respondent. But the accountability framework doesn't stop there, does it? What about the officials?
Right. The Act has a unique dual accountability. Section 33 holds protection officers accountable too. If a PO fails or refuses to do their job as directed by the magistrate without a valid reason, they face the exact same penalties as a respondent breaching an order. Up to 1 year in jail and/or a fine up to $20,000 government.
Wow. So the system holds its own agents accountable.
It aims to. Now, Section 34 adds a layer. Prosecuting a PO requires prior sanction from the state government, protecting them from purely malicious complaints. And Section 35 protects officials for actions taken in good faith. But the potential penalty in Section 33 sends a strong message.
So, as Justice Balakrishnan said, it's a shield for victims and a sword against noncompliance by abusers and officials.
That quote sums it up perfectly. It's designed to ensure the system works as intended, though, as we noted, resource issues and sometimes entrenched attitudes can still pose challenges to realizing this full accountability on the ground. #check HT's form. The PWDVA's transformative legal legacy.
Looking back at everything we've discussed, the PWDVA really does feel like a watershed moment for India. It fundamentally changed the legal landscape around gender-based violence within the home.
Unquestionably. It was transformative. Just think about the key legal innovations we've covered. That hybrid civil criminal approach, focusing on protection but backing it with criminal penalties for breach, that was groundbreaking.
And recognizing economic abuse for the first time.
Huge. And the revolutionary residence rights, especially as clarified by Satish Ahuja, decoupling shelter from ownership.
Right.
Plus the sheer breadth of relationship inclusion, moving beyond just marriage. These were major legal shifts.
What about its broader systemic impact?
It really tried to create an entire ecosystem, mandating coordination between police, courts, POs, NGOs, government departments, shifting the focus firmly onto the victim, her safety, her rights, her empowerment, giving her multiple ways to seek help.
And grounding it all in the Constitution.
Yes, making those rights to equality and dignity real within the four walls of the home. And socially, it's been a powerful tool to challenge patriarchal norms about family, property control, using law to push for social change.
Do we have any sense of the numbers? Has it made a difference statistically?
It certainly has been widely used. Reports indicate well over 1.3 million protection orders have been issued across India since it came into force. That's a massive number, indicating a real need and the law providing a pathway. And we see strong implementation models, as mentioned in states like Maharashtra, Kerala, Delhi, showing what's possible when there's commitment and collaboration. It's provided a crucial, vital framework. #outro.
So that was our deep dive into India's Protection of Women from Domestic Violence Act 2005. We've unpacked its broad definitions, the crucial support network of POs and NGOs, those game-changing residence rights clarified by cases like Satish Ahuja, and the powerful enforcement mechanisms that give it teeth.
It's a remarkably comprehensive law, really quite forward-thinking in many ways. But as we've touched upon, having a strong law on the books is one thing. Making it work effectively everywhere for everyone is an ongoing journey. It needs continued resources, political will, and crucially, ongoing efforts to sensitize society and the officials implementing it. Judicial interpretation also keeps evolving, adapting the law, which is fascinating to watch.
It really is a living law. And that leaves us and you, our listeners, with a final thought to ponder. We've talked a lot about legal rights and constitutional guarantees, but what does a truly dignified life actually mean within a family? And thinking bigger, as a society, how much further do we need to go in reshaping family dynamics, challenging norms to ensure real equality and safety for everyone?
That's the deeper question, isn't it?
Yeah.
The law is a vital tool, maybe the most powerful one we have, but cultural change has to happen alongside it.
Absolutely. Thank you for joining us on this deep dive. We hope it's given you a clear, insightful picture of this incredibly important act and its impact.
Thanks for listening.
Until next time, keep digging deeper. Welcome, curious minds, to another deep dive. Have you ever paused to consider how the precision or sometimes the sheer imprecision of legal language can ripple through society, shaping lives and redefining the very notion of justice? Today, we're zooming in on a single yet immensely powerful legal phrase from a critical piece of legislation in India. We're talking about the Protection of Women from Domestic Violence Act 2005, or the DV Act for short. Specifically, we're going to unravel the complex journey of who exactly can be held accountable as a respondent under this law. It's a fascinating journey through original legislative intent, a constitutional challenge that landed at India's highest court, and a landmark Supreme Court decision that dramatically reshaped the Act's scope and reach.
Indeed. What might seem like a mere technical legal term, respondent, actually holds the very key to understanding who receives protection and, crucially, from whom that protection is sought. This deep dive is all about charting the evolution of a law born out of a profound need to safeguard the most vulnerable and how the judiciary stepped in, not just to interpret, but to truly ensure its fundamental spirit was upheld against unintended limitations.
Our mission today is to give you a clear, concise, and incredibly well-informed shortcut through this pivotal legal shift. We'll explore the original law, the compelling challenge that brought it before the Supreme Court, and reveal the surprising facts about who can now be held accountable for domestic violence within families in India. Get ready for some truly illuminating aha moments that will change how you think about legal frameworks and social justice. Okay, let's unpack this. Before we dive into that crucial Supreme Court ruling, we really need to set the scene. What was the legal landscape like in India regarding domestic violence before and then immediately after the DV Act came into force? It's important to understand the significant gap this law was meant to fill.
You're absolutely right to start there. Prior to 2005, the legal framework in India for addressing domestic violence was, well, quite fragmented, especially when it came to civil remedies. Victims often found themselves primarily relying on Section 498A of the Indian Penal Code. Now, that's a criminal provision which deals with cruelty by a husband or his relatives.
So purely criminal, right? No sort of immediate stopgap.
Exactly. While it provided some recourse, it largely focused on punishment after the fact. It didn't offer a comprehensive suite of immediate civil remedies like protection orders to prevent further abuse, or residence orders to ensure a woman wasn't thrown out of her home, or crucial monetary relief. So there was this glaring gap where women experiencing violence had very limited options for immediate preventative protection and support without having to go down the often arduous criminal prosecution path.
That distinction between criminal and civil is really key, isn't it? It sounds like women had to pursue a much more severe route just to get basic protection. And this wasn't just an internal Indian concern, was it? Was there a broader international push to recognize domestic violence as a human rights issue that influenced this?
You hit on a crucial point there. The impetus for a dedicated civil law wasn't just internal. It was also significantly propelled by a growing international consensus and an almost global awakening to the issue. We saw landmark international accords, like the Vienna Accord of 1994. That was a pivotal moment in recognizing women's rights as human rights. And then the Beijing Declaration and Platform for Action of 1995. Both of these explicitly recognize domestic violence as a severe human rights issue, demanding state action. Furthermore, the UN Committee on the Convention on Elimination of All Forms of Discrimination Against Women, or CEDAW, had consistently urged its member countries, India included, to take more robust protective steps against all forms of violence against women, especially within the family. So this powerful international pressure, combined with the pressing domestic needs, created the perfect storm, if you will, for the DV Act to finally come into being.
So with this international and domestic context, this clear gap in civil remedies, what was the core purpose of the DV Act when it finally came into existence in 2005? What was it fundamentally trying to achieve, and why was it so groundbreaking?
The Act's core purpose, stated right in its preamble, was to provide for more effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family. And that phrase, of any kind, is critical. This wasn't just another incremental legal tweak. It was truly a landmark piece of legislation. It explicitly acknowledged domestic violence not merely as a private social problem, but as a serious violation of fundamental human rights.
That's a big shift.
Huge. It directly connected this protection to India's constitutional commitment to gender equality and fundamental rights. We're talking Articles 14, equality before the law, Article 15, non-discrimination, and Article 21, the right to life with dignity. The Act aimed to provide quick, comprehensive civil remedies, protection orders, residence orders, monetary relief, offering a new legal avenue beyond just criminal punishment. It shifted the paradigm from solely punishing perpetrators to also protecting and supporting victims.
That's a profound shift, moving beyond mere punishment to actively safeguarding rights and dignity. It sounds like the Act was designed to be incredibly broad and inclusive right from its inception. To fully appreciate its scope, we need to understand some of its key definitions, I suppose.
Absolutely. To truly grasp the power and intent of this Act, we need to understand how it carefully defined its core elements. These definitions were really quite revolutionary for their time.
Let's start with perhaps the most fundamental. The aggrieved person, who falls under that definition in Section 2 of who is this law specifically designed to empower and protect.
Okay, the aggrieved person is defined very broadly as any woman who is or has been in a domestic relationship with the respondent and alleges she's been subjected to domestic violence by that respondent. What's crucial here is its inclusivity. This covers women regardless of their socioeconomic status, religion, cultural background.
Right.
Doesn't matter.
Right.
And importantly, it extends to both current and former relationships. This is vital because, the impact of domestic violence often doesn't just stop when someone leaves.
It can continue or even get worse.
Exactly. So a woman who has left can still seek recourse under the Act. That provides a layer of ongoing protection that wasn't really there before in the same way.
That's a powerful extension of protection, recognizing that abuse doesn't just stop at the front door.
Hmm.
And what about the domestic relationship itself, defined in Section 2? This sounds like it could go far beyond traditional marital ties, right?
It absolutely does, and this was one of the Act's most progressive features, really. A domestic relationship refers to a relationship between two persons who live or have at any point in time lived together in a shared household. They must be related by consanguinity, so blood relatives like parent-child, siblings, or by marriage. But here's where it gets truly expansive. It also includes relationships in the nature of marriage.
So that covers live-in relationships.
Exactly. It legally encompassed live-in relationships, common law type situations, even legally invalid marriages where maybe the parties thought they were married. It also covers relationships through adoption or simply family members living together as a joint family. The Act was, in fact, the first Indian legislation to provide legal recognition and protection to relationships outside the traditional bounds of formal marriage. It reflected changing social realities.
So it's about the lived experience of sharing a home, regardless of the official paperwork. That's a massive expansion. But where do these relationships take place? What constitutes a shared household under Section 2's? This also seems designed to be very inclusive.
Indeed, and this definition was another game changer. A shared household is broadly defined as a household where the aggrieved person lives or has lived with the respondent. Could be owned or tenanted, jointly or singly. Now here's the truly revolutionary part, challenging traditional property law. It explicitly includes a household belonging to a joint family of which the respondent is a member.
Wait, okay, slow down.
Regardless of whether the aggrieved person or the respondent has any right, title, or interest in the property.
Wow, so even if a woman doesn't legally own it, her name's not on the title or the lease, she still has a right to reside there under this act if it's a shared household with the abuser. That's huge.
Exactly. Huge. This was a direct challenge to those patriarchal norms where women, maybe especially daughters-in-law, often had no legal claim to the marital home. The act essentially recognized her right to shelter and residence within that domestic sphere, irrespective of ownership. It meant she couldn't just be summarily thrown out if she was facing violence there. It focused on her right to reside, not necessarily her right to own.
Wow, those definitions really broaden protection beyond traditional marital structures and property rights. Very progressive from the start. With such inclusive definitions for who can be protected and where, I imagine the definition of domestic violence itself is equally comprehensive, moving beyond just physical harm.
It absolutely is, and this is where the Act truly sets itself apart, even globally. Section 3 provides one of the most comprehensive definitions of domestic violence you'll find anywhere. It goes far beyond just physical harm, covering any act, omission, or commission or conduct of the respondent that harms, injures, or endangers the physical or mental health, safety, life, limb, or well-being of the aggrieved person. It's a very holistic approach.
So it's not just about obvious physical assaults. What are these 4 pillars of abuse, as you put it, that the Act specifically details? This sounds like a really important distinction.
Indeed, the Act explicitly details various forms of violence. Thinking of them as 4 pillars helps grasp the scope. First, physical abuse. Pretty straightforward. Any act causing bodily pain, harm, danger to life, health, slapping, beating, kicking, pushing, restraint, anything impairing physical well-being. Second is sexual abuse. Any conduct of a sexual nature that abuses, humiliates, degrades, or violates dignity. Forced intercourse, even within marriage, forcing someone to watch porn, unwanted advances. It's about bodily autonomy and dignity.
Okay.
Third, and often underestimated, is verbal and emotional abuse. This covers a wide range. Insults, ridicule, humiliation, name-calling, especially about not having children or a male child, which is culturally significant. Also repeated threats, character assassination, constant harassment causing mental torture. It recognizes the profound psychological harm words and manipulation inflict. No visible scars, but devastating. And finally, a truly significant legal innovation. Economic abuse, often hidden, using financial control to dominate.
How does that work?
It includes depriving someone of financial resources they're entitled to. Think household necessities, her stratehan, her own property, maintenance. Also manipulating assets, selling property without consent, restricting access to things like the kitchen.
Wow.
Studies indicated this affects over 70% of victims in India, yet it's often underreported because financial control can be normalized within families.
That's a truly comprehensive list, and including economic and emotional abuse is striking. Okay, here's where it gets really interesting, though. With such a broad definition of what domestic violence is and who can be an aggrieved person, you'd expect the net for perpetrators to be just as wide. But that wasn't the initial reality, was it?
No, it emphatically was not. You've hit on the central paradox that ultimately led to this landmark legal challenge. Despite Section 3 defining domestic violence itself in a largely gender-neutral way, the act acknowledging that abuse can all be by one woman against another, the initial definition of who could be a respondent, the accused, introduced a very specific restriction.
Right, Section 2Q. That's the one.
That's the one. It became the source of immense debate and legal scrutiny.
Okay, let's get into the specifics of that original wording. What did Section 2Q actually state about who could be named as a respondent?
The Act originally defined respondent in Section 2Q as any adult male person who is or has been in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief under this Act.
Adult male person. Okay, very specific.
Very specific. Right there, the core definition limited the accused to adult male persons. It seemed to create this very narrow tunnel for accountability.
And there was also a proviso to that, wasn't there? What did that add, and how did it interact with the adult male restriction?
Yes, a crucial proviso right after. It stated, provided that an aggrieved wife or female living in a relationship in the nature of a marriage may also file a complaint against a relative of the husband or the male partner. Now, this proviso seemed to offer a slight opening, allowing for maybe female relatives of the male abuser, but it still operated under the shadow of that main adult male restriction.
So you could maybe add female relatives, but only if they were connected to an adult male respondent. Or only if you were a wife. It sounds complicated.
It was. The implication was pretty much that. It didn't clearly allow for a direct, standalone complaint against, say, just a mother-in-law or sister-in-law if there wasn't an adult male also being proceeded against.
This wording certainly presented an immediate challenge. The Act recognizes violence broadly, but then narrows who can be held responsible. Did courts try to work around this early on? Did they sense the intent was maybe broader?
They absolutely did. You could see a clear discomfort with that restrictive wording. Even before the big Supreme Court decision, courts recognized the practical realities and tried to interpret Section 2Q more broadly. For instance, back in 2011, the Supreme Court in Sandhya Manoj Wankade v. Manoj Bhimrao Wankade noted that the legislature likely never intended to exclude female relatives from the complaint. They reasoned that if the legislature really wanted to exclude all females, they would have said so explicitly. It signaled a strong judicial leaning towards widening the scope, even if it meant stretching the literal text a bit.
That's a telling sign when courts start interpreting intent beyond the strict words. And there was another interesting case in the Delhi High Court that took this even further, right?
Precisely. The Delhi High Court, in Kusum Lata Sharma v. State and Honor, actually held that a mother-in-law could file a complaint under the Act against her daughter-in-law.
Wow, the other way around.
Exactly. And what's more significant is that the Supreme Court later dismissed an appeal against this decision, essentially letting that interpretation stand. It indicated a growing judicial understanding that violence could flow in multiple directions within a household, and restricting the respondent to adult male was just creating an artificial barrier.
So what does this all mean? It seems the courts were trying to stretch the definition, but that explicit phrase, adult male, remained a real sticking point, created a complex, maybe inconsistent legal landscape. It almost feels like the legislature's broad intent to protect women from all family violence was being undermined by this one specific phrase.
That's a perfect summation. These practical limitations and inconsistencies meant the legislature's true intent was being severely hampered. The adult male restriction created what the Supreme Court later called an invidious discrimination, leading to significant loopholes that contradicted the Act's whole purpose.
How specifically could restricting the respondent to only an adult male undermine the objective? Can you give us a concrete picture of how these loopholes played out?
Well, the problem was substantial, with real-world consequences. If reliefs like protection orders, residence orders, money custody, if they could only be sought against an adult male, the entire act could be easily defeated. Imagine. A male perpetrator, aware of this loophole, could strategically orchestrate violence through female family members. His mother, sisters-in-law, they could aid, abet, or directly harass, mentally torture, even physically exclude the woman from the home.
And they wouldn't be the official respondent.
Exactly. These female relatives could effectively skuldify the reach of such protection orders by carrying out the abuse, while technically being outside that core definition. The act just couldn't effectively address the complex dynamics of joint family violence where multiple people often play a role.
That's incredibly frustrating for a victim. Like designing a fortress with an impenetrable front gate but leaving the back door wide open for accomplices. And what about the adult factor? That must have created another strange anomaly.
Absolutely. The restriction to adult male also created a significant anomaly. The court later observed it's not difficult to conceive of a non-adult 16 or 17 years old member of a household who can aid or abet domestic violence or help evict someone.
Right, a teenager could be involved.
Yeah. So a perpetrator could use a minor family member to throw belongings out, verbally abuse, and that minor would be beyond the reach of the act's specific remedies. It showed a real disconnect between messy family dynamics and the rigid legal definition.
So, female relatives, non-adults, actively participating, but maybe not directly accountable under the DV Act itself. That seems inherently unfair and created a strange procedural disparity, didn't it? Pushing victims towards other legal routes.
Precisely. The Supreme Court highlighted this as invidious discrimination. It noted that the same reliefs under the DV Act could be sought against female family members in other courts, civil, family, criminal courts under different laws, but were restricted under the DV Act itself unless an adult male was also named.
So the remedy depended on which door you knocked on.
Pretty much. It meant the availability of justice depended arbitrarily on which legal avenue a victim chose. An unfair and illogical distinction. The court basically said there was no intelligible differentia, no clear, rational basis for this difference, especially when the goal was the same, protecting women from violence.
This brings us to the pivotal moment, the ultimate test. A case that went all the way to India's Supreme Court, directly challenging the constitutional validity of that phrase, adult male, in Section 2Q.
This was indeed a monumental challenge. The case, Hiral P. Harsora v. Kusum Narottamdas Harsora, decided October 6, 2016. A direct confrontation with that restrictive interpretation, a real turning point.
Tell us a bit about the origin story. How did it reach the Supreme Court? What were the stakes for the people involved?
It originated from a complaint filed way back in April 2007 by Kusum Narottam Harsora and her mother, Pushpa. They alleged numerous acts of domestic violence against Kusum's brother, his wife, and his two sisters.
Against multiple family members, male and female.
Exactly. Imagine the courage that took. Initially, the Metropolitan Magistrate, sticking strictly to Section 2Q, dismissed the complaints against the female relatives and a minor boy. Said only adult male respondents could be proceeded against.
Leaving the women feeling unprotected from some of the alleged perpetrators.
Right. So the trial court held strictly to the letter of the law. What happened when it went up to the Bombay High Court? Any reprieve there? The Bombay High Court's earlier ruling tried to clarify but didn't fully solve it. They said the DV Act could be used against adult males and female relatives, but a complaint against female relatives was only maintainable if they were co-respondents with an adult male member in that domestic relationship.
Ah, so you still needed that adult male link.
Yes. Crucially, a complaint filed solely against female relatives, without an adult male also named, was still not maintainable under the DV Act, according to the High Court at that point. This forced Kusum Harsora and her mother to challenge the very constitutional validity of Section 2Q itself before the Supreme Court. They were basically saying this wording fundamentally undermines the Act's purpose and our right to protection.
This was the ultimate test. The narrow wording under scrutiny, not just for interpretation, but for its very existence. What was the Supreme Court's reasoning as it analyzed these challenges? What principles did they lean on?
The Supreme Court meticulously analyzed it, relying on several fundamental principles of law and justice, effectively dismantling that restrictive interpretation. First, it heavily emphasized purposive interpretation and legislative intent. Citing precedents, they stress looking beyond literal words to discern the true purpose and prevent provisions becoming futile.
Right. What was the law meant to do?
Exactly. The judges reasoned the DV Act was meant to afford the largest possible protection to women from domestic violence by any person, male or female. That was foundational.
So, looking at the spirit, the overarching goal, and the gender neutrality of the violence itself must have played a big role.
Absolutely. That was the second critical pillar. The judges reiterated that domestic violence, as defined in Section 3, is inherently gender neutral in its commission. They pointed out, logically, that physical, sexual, verbal, emotional, economic abuse can all be by one woman against another. They also considered the non-adult factor, noting a 16 or 17-year-old could realistically abet or perpetrate. This practical understanding powerfully reinforced that restricting accountability to only adult males was illogical and ignored the realities of family abuse.
That makes perfect sense. The law defined violence broadly, but then contradicted itself by narrowing who could be held responsible. This brings us to the core constitutional argument.
Indeed. The core reasoning centered on Article 14 of the Indian Constitution, the fundamental guarantee of equality before the law and equal protection of the laws. The court found the phrase adult male in Section 2Q imposed an arbitrary and discriminatory limitation. Basically, this classification distinguishing adult males from others lacked an intelligible differentia.
Meaning no good reason for the difference.
Pretty much. No clear, rational basis for distinguishing between adult males and other potential perpetrators that serve the Act's purpose. Furthermore, this distinction had no rational relation to the Act's objective of protecting women from all forms of domestic violence. Therefore, the restrictive language was unconstitutional, an unfair distinction without a justifiable purpose related to the Act's goals.
That's a powerful application of constitutional law. And linking back to the loopholes, the court also considered how this restriction defeated the Act's objective practically.
Yes, a key pragmatic part of their reasoning. They highlighted that if reliefs were confined only to adult males, the Act's objective could be easily defeated by adult males acting through female or non-adult family members. These individuals could actively participate, stultifying the reach of such protection orders, rendering the Act toothless in complex family situations. This practical point reinforced the constitutional flaw. The literal interpretation actually undermined the law's very purpose.
It's a powerful demonstration of how legal definitions must align with constitutional principles and practical justice. So what was the ultimate verdict? How did the Supreme Court finally rule on adult male in Section 2Q? What was the direct impact?
In that landmark verdict on October 6, 2016, the Supreme Court unequivocally struck down the words adult male before the word person in Section 2Q of the DV Act. The court stated clearly that these words discriminate between persons similarly situated and far from being in tune with, are contrary to the object sought to be achieved by the Act. A direct, definitive order removing that restrictive language.
And what about that proviso we discussed, the one allowing complaints against relatives of the husband or male partner? Was it affected?
Yes, as a direct consequence, the proviso to Section 2Q was rendered otiose. That's legal speak for superfluous, without purpose. So it also stood deleted. Its original purpose was to carve out an exception to include female relatives when the main rule was adult male. Once that main rule was gone, the exception wasn't needed anymore.
How did the court ensure striking down these words didn't invalidate the whole act? Was there a legal principle to preserve the rest?
Yes, absolutely. They carefully applied the doctrine of severability, a crucial principle in constitutional law. It basically says if one part of a law violates the Constitution but can be cleanly separated from the rest, the court strikes down only the bad part, not the whole statute, like precise surgery.
Got it.
By applying this, the court clarified that removing only adult male left the rest of the Act intact and can be enforced to achieve the object without the offending words. It preserved the core protective framework.
So what's the practical outcome then? What does respondent mean now for women seeking protection under the DV Act?
The practical outcome. The definition of respondent was broadened significantly. It now encompasses any person, regardless of gender or age, who is or has been in a domestic relationship with the aggrieved woman and against whom relief is sought. This means a complaint can be filed against any individual in that relationship, male, female, adult, non-adult, if they allegedly committed domestic violence as defined by the Act. A fundamental reshaping of the law's reach.
This was a powerful paradigm-shifting moment, fundamentally altering the Act's application. It really feels like a triumph for the original legislative intent, finally making the law match its purpose.
This judgment truly transformed the landscape. By removing the adult male restriction, the Act now unequivocally protects women against domestic violence by any family member, irrespective of gender or age. A crucial step towards aligning the law with the complex realities.
So it effectively closed those glaring loopholes, where perpetrators could act through others and escape direct accountability under the Act. That must provide huge clarity.
Exactly. The decision closed a significant loophole, ensuring victims aren't rendered remediless under any garb whatsoever. It harmonized the definition of the perpetrator with the gender-neutral nature of violence itself, treating abettors and perpetrators equally under the Act. It provided clearer guidance, enhanced the Act's effectiveness, and set a powerful precedent for interpreting laws to serve their true social purpose.
Sounds like an unmitigated win for victims. However, are there any nuances or limitations we should still be aware of, even with this expanded definition? Is it truly a blanket application?
Yes, it's crucial to acknowledge some nuances. While the definition of respondent became gender-neutral for who can be accused, the Act still retains some specific protections, particularly for women who might be respondents. For instance, Section 19 deals with residence orders ordering someone to leave a shared household. It explicitly states that no order under clause B directing the respondent to remove himself or herself from the shared household shall be passed against any person who is a woman.
That's a really important distinction. So a woman can be named as a respondent for, say, verbal or economic abuse, but the Act specifically prevents her from being evicted from the shared household via a residence order under this Act. Why that carve-out?
It's a very significant provision. It acknowledges women's particular vulnerability to homelessness and aims to prevent the Act being misused against other female family members in displacement scenarios. Given the societal context, forcing a woman out, even if she's a respondent, could render her completely destitute. It shows a nuanced approach, balancing accountability with recognizing broader gender-based vulnerabilities.
That's fascinating, highlighting the ongoing tension in crafting laws that are both robust and equitable. Were there any critiques of the judgment's reasoning, even with its positive reception? Because in law, there are always different perspectives.
You're right, even landmark judgments face scrutiny. While largely lauded for the outcome, some legal analyses, like Aparna Chandra's critique, argued women should perhaps be exempt as respondents in certain contexts, particularly against marital relatives.
Why? What was the reasoning there?
The argument is rooted in power differentials within the family. It suggests women perpetrating violence like a mother-in-law might themselves be acting under the influence or direction of patriarchal figures. Basically, their agency might be constrained within that structure. Another critique noted the court's reasoning relied on comparisons to other laws, like the Workplace Sexual Harassment Act, which some argued wasn't entirely logical given the DV Act's specific legislative history, where Parliament had apparently swung between more inclusive and exclusive definitions previously.
It's crucial to acknowledge these complexities. So, has there been any legislative follow-up? Has Parliament moved to codify this judicial interpretation into the statute itself to remove ambiguity?
Yes, illustrating how laws keep evolving. The Protection of Women from Domestic Violence Amendment Bill 2022, introduced by Dr. Sujay Radhakrishna Vikhyapatil, seeks to do exactly that, codify the Supreme Court's judgment.
What exactly does this proposed bill aim to change in the text? How would it align the wording with the ruling?
It explicitly proposes substituting any adult male person with any adult person in Section 2Q. Simple, direct incorporation of the court's removal of gender and age restrictions. And to remove any ambiguity after the proviso was dropped by the court, it also seeks to clarify the proviso to explicitly include female relatives of the respondent husband or the male partner, making it crystal clear they can be named.
What's the rationale behind the bill, especially after the Supreme Court ruling? Just clarity or more to it?
Definitely clarity, but also reinforcing legislative intent and addressing ongoing realities. The bill's statement of objects explicitly cites the Harsora judgment and the need for legislative action to simplify the law and make the respondent gender-neutral statutorily. It highlights the real phenomenon where the mother-in-law and sister-in-law could be involved, underscoring the practical necessity. It also points to the dramatic rise in DV cases during the COVID-19 pandemic. The National Commission for Women received its highest complaints since 2014 and 2021, 31,000 cases.
Wow.
So it indicates that legislative confirmation and clarity are still seen as vital, especially in times of crisis.
This proposed amendment really demonstrates that ongoing dynamic nature of lawmaking. So looking broader, how has the Harsora judgment and the DV Act's overall framework impacted the fight against domestic violence, and what critical challenges still remain?
The Harsora judgment significantly strengthened the Act by removing a major hurdle. The Act's overall framework is widely praised for being victim-centric. It set up multi-agency coordination police, judiciary, protection officers, service providers, a much more robust support system than before. It's also lauded for its constitutional alignment, and the results are tangible. Over 1.3 million protection orders issued nationwide. That shows its broad impact.
Those numbers are impressive, but any major legislation like this faces ongoing criticisms and implementation challenges, right? What are some of those persistent hurdles?
Indeed. Despite its scope, the DV Act faces critical implementation gaps. A big one is lack of public awareness, especially in rural areas. Many women just don't know their rights under this law. Protection officers, central to the Act, are often severely overburdened, sometimes holding the role as an additional duty. That impacts effectiveness.
Right, they can't dedicate full time to it.
Exactly. Plus, there's often a scarcity of immediate relief beyond shelter homes, comprehensive medical aid, trauma counseling, financial help to rebuild lives. These aren't consistently available everywhere.
And what about the concerns sometimes raised about potential misuse? That often comes up in these discussions.
That's an ongoing debate and a criticism we have to acknowledge. Some men's organizations, like the Save Indian Family Foundation, express concerns about potential misuse in contentious matrimonial disputes,